I'm Ken Washington, CEO of Education Resource Paralegals. I want to give you some disclosures. By proceeding to listen to this, you acknowledge that I am not giving you legal advice, but rather this is education. So basically everything that I'm sharing with you is educational. The topic that I want to discuss with you today is a type of discrimination referred to as retaliation. Basically, with retaliation, whenever retaliation occurs, then the burden is on the person complaining to articulate a case. It's commonly referred to as a prima facie case of retaliation. And don't worry, I'm going to go back and explain all of these terms that I'm using. Prima facie means, if you literally translate it, it means at first sight. So on its face or at first sight, it looks like the situation is retaliation. Now, just like with every law, retaliation has certain elements that have to be present in order for a plaintiff, and the plaintiff is the one bringing the complaint, in order for a plaintiff to be able to prove from a legal perspective that retaliation in fact occurred. So what are the elements? Number one element is that the plaintiff engaged in protected activity. Number two, the plaintiff suffered an adverse employment action. And the third is that a causal link exists between the protected activity and the adverse action. You can have that causal link or you can show that similarly situated people in your workplace were not disciplined for engaging in the same behavior for which you were disciplined, for which you suffered an adverse employment action. Now let me circle back and talk about some of these terms that we used. We already talked about what prima facie is, but what is retaliation? Retaliation is basically, it is what those elements define there, but more specifically, let's say you raise a concern about discrimination at your workplace and you communicate to your employer that there's a problem, and then they do something to get back at you. That's basically what retaliation is. But from a legal perspective, those elements that we talked about clarify exactly what you need to show in order to prove that retaliation from a legal perspective actually did happen. So we said that one of the elements is engaging in protected activity. Protected activity is any activity that's covered in Title VII of the Civil Rights Act, and specifically addressed to be something that the law is going to protect. And for the purposes that we're talking about in terms of employment discrimination, that's discrimination on the basis of race, color, sex, nation of origin, religion, sexual orientation, all of those things. There's a couple more, but all of those things are statutorily protected statuses. And so if you raise a concern with your employer about anything that's covered under Title VII, then that is protected activity, and it's specifically protected under Title VII. So the next thing is, what is an adverse employment action? Well, an adverse employment action, depending on the type of discrimination that we're talking about, it has different definitions. When you review case law, it has different elements that need to be satisfied. So in So on the subject of retaliation, an adverse employment action is an action that your employer takes that would dissuade a reasonable person from filing a complaint or making a complaint in the future. So the burden is to show that the action that was taken against you would really make someone else in your position say, oh no, I'm not going to do that because I saw what happened to him and I'm not going to do that. And if a reasonable person would take that position, then that's enough. That's sufficient to prove that that the action taken against you was an adverse employment action. All right. So what is a causal link? Now, remember, a causal link has to exist between the protected activity that you engaged in and the adverse employment action that was taken against you. So how do you show that those two things are connected? The causal link is how you show that. Sometimes referred to as a causal nexus. So the thing with that, you can show it by the length of time that has passed. They call it a temporal proximity. A temporal proximity is the length of time that exists between the time that you engaged in that protected activity and the time that your employer took the adverse action against you. In most situations, I'd say generally speaking, if you study case law, the acceptable period of time is about 3 months or less in order to satisfy the condition of showing a causal link or a causal nexus. Now, that time period in some cases, in some very unique cases, has been years have passed and you still have a causal link and causal nexus. So the point of that is that generally speaking, yes, it's about 3 months or less, but depending on the circumstances, it could be, you could have a longer period of time between the protected activity and the adverse action and still be able to, prove that there is a causal link between those two events. Okay, so what the next part is, we said that you could also show that similarly situated peers were not disciplined for engaging in the same activity for which you were disciplined. Okay, so what do we mean by similarly situated? Similarly situated peers are gonna have like the same job description, the same supervisor, the same general responsibilities. These are folks who are in a similar category as you. You might even have the same job title. And if they were doing the same thing that you were doing, and you suffered the adverse action for it, but they did not, then you can use that information to prove through circumstantial evidence that the employer in fact did retaliate against you. So those are the elements that we're looking at to prove to show a prima facie case of retaliation. Again, we have that that you engaged in protected activity, you suffered an adverse employment action. There's a causal link or causal nexus to connect the protected activity with the adverse employment action, or similarly situated peers who engaged in the same behavior as you, not the protected activity, but the activity for which you were being disciplined. They engaged in that behavior and they did not suffer an adverse employment action as you did. And so that's how you show your prima facie case of retaliation. Now, after you show the prima facie case of retaliation, then the burden shifts to the defendant, to your employer, to show and to produce actually legitimate explanation, a legitimate reason for the adverse action taken against you. Adverse action could be, some examples, it could be that you lost your overtime. It could be that you were demoted. It could be that you were terminated. There are a number of different things that could constitute an adverse employment action. For the purposes of retaliation, the condition of satisfaction is that it would dissuade a reasonable person. The action they took would dissuade a reasonable person from engaging in that activity. So now that the burden is on the employer, then all they have to do, they have the burden of production. They don't have the burden of persuasion. The burden of production is very low. All they have to do is come up with, any legitimate reason as to why they took the action they took. So say we're talking about termination, and they say, hey, we just didn't need them anymore. The budget wouldn't allow for us to justify keeping them. Well, when they make that excuse and they put that out there, then your prima facie case goes away. It's all done, and at that point, the burden shifts back to you as the plaintiff. And at that point, you have to show through a preponderance of the evidence that what your employer said is pretext for retaliation. So what do we mean by a preponderance of the evidence? We're talking about 51%. So we need to, at that point, you need to show through circumstantial evidence that there's a series of things that happen that, when viewed in a context as a whole, that would prove, at least to the degree of 51% or more, that the proffered explanation given by your employer is a lie. Okay. And if you can produce enough information to show that, then the fact finder, whoever that is, would rule in your favor. And that is how you basically win a prima facie case of retaliation. If you like this video, I'd like for you to like it and share it, and also subscribe. And I'll be giving you more information as we go along. Thank you.